Cool. War on the Judiciary. So, one of the things that happened during Jefferson's presidency was an issue with the Supreme Court. As you know, or should know, the president appoints judges to the federal and Supreme Court. This is exactly what John Adams did 5 days before he was done being president. He appointed 16 judgeships under the Judiciary Act of 1789, which established how judges would be placed in office. Those judges he appointed supported federalism, which is logical because he wanted federalism to stay alive after he was gone. So why not appoint people who are appointed for life? These judges were also called midnight judges because they were appointed supposedly too late to refuse. So Jefferson's supporters in Congress repealed the Judiciary Act. And William Marbury, who had been appointed to a judgeship by President Adams during his last hours of office, filed a suit. So basically he was suing the Secretary of State who refused to give him his appointment, and that would have been James Madison. So Marbury asked the Supreme Court to order the Jefferson administration to give him a formal letter of appointment. And the case threatened a direct confrontation between the judiciary and the executive and legislative branches of the federal government. If the Supreme Court ordered James Madison to give Marbury his judgeship, the Jefferson administration was probably going to ignore what the court said. So John Marshall, the new Chief Justice of the Supreme Court, was well aware of the court's problem. When Marshall became the nation's fourth Chief Justice in 1801, the Supreme Court lacked any prestige and public respect. Presidents found it really difficult to find willing candidates to even serve as justices. The court was considered so insignificant that it held its sessions in a clerk's office in the basement of the Capitol and only met 6 weeks a year. So when Chief Justice Marshall and the court listened to all the arguments from both sides, the Supreme Court Justice comes up with opinion after they all vote. And this was what his opinion was. Marshall said, okay, Marbury had a right to his appointment, but he also ruled that the court had no authority to order the Jefferson administration to even act, since the section of the Judiciary Act that gave the court the power to issue an order was unconstitutional. For the first time, the Supreme Court had declared an act of Congress unconstitutional. Though Marbury versus Madison was a landmark in American constitutional history, the decision established the power of the federal courts to review the constitutionality of federal laws and to invalidate acts of Congress when they are determined to conflict with the Constitution. This power is known as judicial review, and it provides the basis for the important place that the Supreme Court occupies in American life today. Interestingly enough, nowhere in the Constitution does it even say that the Supreme Court has the power of judicial review. As part of his opinion in Marbury versus Madison, Marshall says that it is emphatically the province and duty of the judicial department to say what the law is. And this case established the Constitution as the supreme law of the land. Some interesting facts today about our Supreme Court. So these are our justices. There are 9 of them. Now, figure out why we would have 9. Just roll that around in your head. So starting from the left to right in the back row, we have Sonia Sotomayor, our first Latin American justice, then Stephen Breyer, Samuel Alito, and Elena Kagan. From the front row, left to right, is Clarence Thomas, Anton Scalia, Chief Justice John G. Roberts, Anthony Kennedy, and Ruth Bader Ginsburg. Whee! And the Senate is the group that confirms the appointment. So this is not like a one-on-one interview. Obviously, you can tell that the press is there. And whoever these people are, they're listening in on the questions and the answers from Ms. Sotomayor. No pressure at all, right? So this is the top of the Supreme Court building, and it is stamped in there. It says equal justice under the law. So just think about that phrase. What do you think equal justice actually means? And when the Supreme Court was created, did it mean equal justice for everyone? And I think that's what the beauty of our Constitution is, that it is flexible, in that equal justice didn't mean equal justice for everybody in 1789. Think about who didn't have equality back then. And I'm not talking about just slaves either. I'm talking about women and other minorities. And as our values change over time, our government and our laws change as well. And so I think what's really cool about our system that we have created is that this document called the Constitution is flexible enough to go with the flow, so to speak, as our values and priorities change. So equal justice under the law back then was certainly different than it is today. Here's the front of the Supreme Court. I don't know if anybody's ever been. I have not, actually. It's one of my bucket lists of places to go. This last slide includes famous cases that have been heard in the Supreme Court that has had a direct impact on the United States. In 1896, there was a court case called Plessy versus Ferguson, where Mr. Plessy was an African American who was actually really light-skinned, and he lived in Louisiana, where the code or the law was there was a separate train car for blacks and then a separate train car for whites. And the law was that as long as the train cars were equal in quality, then it was okay. That's where this separate but equal comes into play. Remember, equal justice under the law. So he was arrested and put into jail because he rode in a white train car, basically. And the Supreme Court upheld that it was legal to have separate public facilities for blacks and for whites, as long as they were equal. Now, do you think that actually happened? Those public facilities being equal? No. And that's where this next case comes up. Brown versus Board of Education in 1954. So this is almost 60 years later that, black children going to school did not have equal facilities. In fact, they were being hindered because the facilities were not equal. They may not have had running water or electricity in their schools, while the white kids in the same district did. And so many states got together and petitioned the Supreme Court, saying the school segregation is not equal. It's definitely separate, but it's not equal. And this court case banned segregation in schools, which later opened the door for movie theaters, for water fountains, for public restrooms to be integrated rather than segregated because of your skin color. Gideon versus Wainwright was discussed in 1963. Amendment 6 of the Bill of Rights says you have the right to remain silent, right? But it also says you have the right to an attorney. And Gideon was accused of stealing change out of a vending machine, and he was not able to afford a lawyer. And so if you can't afford a lawyer, you're probably not going to get the best representation, especially if you represent yourself. So obviously he was found guilty and was put in prison. And he petitioned the Supreme Court and said, that's not fair. I have a right to counsel, and especially since I didn't do it. And just because I can't pay for one doesn't mean I can't have good counsel. And so the Supreme Court heard it and said, you know what, you're right. So no matter what crime you've committed or where you've done it, you have the right to have an attorney for you. This next one might sound familiar to you. This also has to do with Amendment 6. You have the right to remain silent. You have, which is what this is about. In 1966, a guy named Miranda was accused of and convicted of raping a woman, and under interrogation he confessed, but he was not read his rights. So he took it all the way to the Supreme Court and sued, and the Supreme Court said, you know what, you're right. Amendment 6 does say you have the right to remain silent, and anything you say can be used against you, but those rights weren't given to him. And the verdict was reversed, and he was released from prison. He actually did do the crime, but because the police did not Mirandize him, which is what that comes from, this case, he was let go. Roe v. Wade is also a very famous case. In 1973, Roe sued for the right to have an abortion, and the Supreme Court said that is correct. She does have the ability to have an abortion. And one of the most recent ones that you may have heard of is Obergefell versus Hodges, where the Supreme Court upheld the right for gays to marry. And this was under the Equal Protection and Due Process, which equal protection is under the 14th Amendment and due process of law is under the 5th Amendment. So there are still cases out there that the Supreme Court definitely has had a huge impact on the way we live today. So from 1896, which, from our standpoint, the separate but equal was terrible, and sorry and sad to say that the Supreme Court of the United States, the highest court in the land, said segregation was okay based on race. But again, as times change and values change, we had Brown versus Board of Education that said segregation was not good, and the Supreme Court was able to reverse their decision 60 years later to give equality to all, not just a few. And that's still going on today in terms of, laws that are being questioned, so to speak. So there you go. Those are just a few of the things. But again, as a summary, the first landmark case that really established the ability for the Supreme Court to make these kind of decisions was Marbury versus Madison. So what I'd like you to do now is go to our filing cabinet and find the Marbury versus Madison handout and complete the exercise. This will be necessary for you to take the assessment at the end of this unit. Awesome. Thank you for listening. You can always go back and listen again. Bye.